Now, to help us break down what happened inside the courtroom this week and perhaps the strategy that might be playing out behind the scenes, let's bring in Duncan Levin, the former Chief of Asset Forfeiture for the Manhattan District Attorney's Office, now a criminal defense attorney with Levin & Associates. Duncan, thanks so much for joining us.
Good afternoon. Thanks for having me on.
I want right away to get your takeaway from this David Pecker testimony, because the prosecution has been able to elicit a lot of perhaps damaging details about Trump from a man who says Trump was his mentor.
Well, this testimony is so critical to the case, and it's not a surprise that they're putting him on first. This case is really not about falsifying business records, even though that's what Mr. Trump has been charged with. Falsifying business records is a misdemeanor. Falsifying business records with the intent to defraud is a misdemeanor. Falsifying business records with the intent to defraud and to commit another crime is an E felony. And so today, for the first time, and this week for the first time, through the testimony of David Pecker, the DA's office's case has finally come into more of a focus. And we now know what that underlying crime is actually. And it's a violation of a New York State election law statute that discusses a conspiracy to basically win an election with unlawful means. And that is what this case now is about. And so they're using David Pecker's testimony to show that Michael Cohen was a conduit between him and the National Enquirer and Mr. Trump to do something that went way beyond what is known as catch and kill, which is a questionable journalistic technique to begin with, where some outlet might buy a story and kill it. They're saying this went way beyond
this conduit relationship with Michael Cohen, because a lot of Pecker's testimony is talking about his conversations with Michael Cohen, which we'll get to Cohen's issues as a witness potentially in a minute. But one of the key things prosecutors have to show here is knowledge that Trump knew what he was doing was illegal. And from Pecker's testimony, do you think we have that yet? That's a high bar for prosecutors, don't you think?
I do think that it's being established. It's going to come in through a number of critical witnesses, both Mr. Pecker, but also Mr. Cohen. Both of those are going to go to show first the conduit between Trump and the National Enquirer and how he directed that and how closely he worked with the Enquirer. But you're right. The prosecutors are going to need to show that Mr. Trump had the knowledge that these falsified business records were being done to cover something up, and that he was covering up some kind of criminal activity. They're using Mr. Pecker right now just to show the criminal activity. They're using him to show the fact that he worked so closely with the Trump campaign, and that this was basically a conspiracy to subvert the election by giving both expenditures and campaign contributions that they weren't otherwise allowed to do. That's what they're using him to show.
You've been in front of dozens of New York juries. How do you put a witness on the stand that has real credibility issues, that is an admitted liar like Michael Cohen?
As a prosecutor, we always used to say to a jury that we don't pick and choose who the witnesses to the crime are. The witnesses to the crime are who they are. If we got to pick, we would go through our Rolodex and we'd go to P and we'd pull out the card that says Pope, and we would call the Pope as our witness. But that is not the way the real world works. And it works the same way on the defense side. You get who you get. And so these are flawed witnesses in many ways. They are, Mr. Cohen in particular, Michael Cohen has been convicted of perjury, of lying. He's lied in federal court before. He has a lot of baggage. And so obviously he and Pecker are going to be attacked by the defense over their credibility, and the chips are just going to fall where they lie. But I think at the core of it, there's enough paper trail there to sort of corroborate. And I think the way that the prosecution is going to aim to get through their problems is by corroborating everything they say against another piece of information, and say this case is like a jigsaw puzzle. The pieces fit together. Use your common sense and see how that works.
And just quickly here at the end, you've been a prosecutor, but you also have been on the other side defending a criminal, a charged criminal. Would you tell your client, former President Donald Trump, to take the stand? Do you think he will?
I think there's almost negligible possibility that he is going to take the stand. In this case, he does have something to offer because he could negate the intent. The intent here, remember, is to falsify the business records with the intent of committing another crime. He could get on the stand and say, that wasn't my intent. My intent was to shield Melania from finding out that I was having an affair, or it was to, he could come up with some other reason that that was actually his intent. But at the end of the day, I think that it's highly unlikely, because he is going to get absolutely destroyed on cross-examination.